Hello everyone, good evening. Myself Yusra Khan, convener of Lawlicious. Lawlicious is an organizing committee founded by Mr. Vivek Dikshit, which provides knowledge about internships, debates, and moot court competition. It focused on promoting legal awareness through various webinars and competition for scholars, which is beneficial for all law students. Now, I will like to introduce our first keynote speaker, Mr. Souradipta Bandyopadhyay. He is an assistant professor at Brainware University Kolkata and former practicing advocate. He is pursuing PhD in law in the domain of the green criminology. He presented 25 research papers at national and international conferences. He published 16 research articles, including SCOPUS, WAS, and UGC care listed journals. Up to you, sir.
Well, thank you for this invitation and this warm welcome. So, good evening, everyone. Myself, Souradipta Banerjee. So, as the topic suggests, we'll talk about the features of Indian Constitution. So, am I audible? Please kindly.
Yes, sir. Sir, you are audible.
Okay. So, there are other panelists as well. So, basically, first, let me remind you today is a very special day for the law students like us. As we all know, it is a very significant day for our Indian Constitution. So that's why we would like to, I would like to discuss few significant features of our Indian Constitution. So, as we all know, Constitution is one of the supreme law of the land, and it serves as a cornerstone for India's democratic framework. So, after a lot of struggle, after a lot of sacrifice, we got ourselves a constitution. So, it was adopted on this date, November 26th, 1949, and enforced from January 26th, 1950. Actually, this is one of the lengthiest and one of the most comprehensive constitutions in the world, crafted with visions of accommodating India's diversity and challenges as well. And this Indian constitution, it actually embodies several unique features. So it will be more it will be more interesting. This session will be more interesting if you interact with me actually. Okay, so if you have any questions related to the constitution or related to the features of Indian constitution, you can certainly ask me. All right. So one by one, let me explain these features. First one, I think the federal structure with along with an unitary bias. You see, there are two systems. India follows a unique federal system where the power of the constitution is divided between the union and the state governments. However, again, there are some certain situations where, for example, like national emergency, the constitution gives power or tilts toward the unitary system, means centralizing authority with the union government. Certainly, it has given an upper hand towards the union government. Apart from that, there is a sacred division of power between the state government and the union government. There are three lists actually: union list, state list, and concurrent list. Through this list, actually, the power has been divided between the union and the state. Next is the parliamentary system of the government. So basically, this parliamentary system was inspired by the British model. India actually adopts this parliamentary system where the president is the nominal head, amazingly, and the prime minister, along with his cabinet or council of ministers, holds the real executive power. Means the president is actually the pseudo head here, and the government itself is accountable to the legislature, ensuring who is ensured ensures the democratic governance. Okay, so there are two houses, Lok Sabha, upper house and lower house in the parliament itself, where the president plays a very nominal role there. I think you all have seen the debates or the parliamentary proceedings happening in the parliamentary house. So there you will see all the actions has been done by the MPs and MLAs and the cabinet and all. Whereas the role of president there is very less. And the next feature, that is, I think as a law student, we are all aware of, that is our fundamental rights. Right now, one of the major topics, not only for a law student as well as for a layman, we should all be aware about our basic rights. So constitution has guaranteed six basic fundamental rights, that is right to equality, right to freedom, right against exploitation, right to freedom of religion, then right to cultural and educational rights, and last but not the least, that is right to constitutional remedies. So additionally, in 42nd amendment, the fundamental duties were also been incorporated or introduced in our Indian constitution. I think we all have seen the movie Spider-Man. So there was a very famous dialogue in Spider-Man that was, with great power comes great responsibility. So these fundamental rights are power given to the citizens of the India. So along with this power comes a responsibility, that is a duty towards our motherland, that is called fundamental duties. Okay, it is also one of the unique feature of our Indian constitution. And apart from that, we have DPSP, Directive Principles of the State Policy. Actually, this concept has been adapted or borrowed from the Irish constitution. It guides the state or the government in framing laws, policies aimed at achieving social and economic welfare. Although non justiciable, they are considered fundamental in the governments of the country. Only it is obligatory actually. Okay. Now, again, another major feature is independent judiciary. Our constitution actually has established an independent judiciary which acts as the guardian and the interpreter of the constitution. This judiciary actually ensures the rule of law, protect the fundamental right of us, and resolve any dispute between the union and the state. Okay. And next feature is universal adult franchise. So that means our constitution provides for universal adult suffrage, meaning allowing every citizen who is aged above 18 and who above 18 has got the right to vote irrespective of caste, religion, gender, or social status. This feature actually underscores India's commitment to democratic principles. So, for me, these are the major features of our Indian Constitution. I guess there are two other panelists here who can elaborate on this aspect. However, I would also like to discuss another feature of Indian Constitution. Well, that is right now a major topic for debate. That is secularism. Now, we all know, or we all have heard this term secularism. It's under Indian Constitution refers to the principle of maintaining a neutral relationship between the state and the religion. Well, our state has no religion actually. The Indian model of secularism is actually distinct as it neither promotes nor discriminates against any religion. It ensures freedom of religion to individuals and groups while regulating religious practices to afford actually public order, morality, and health. Means no right is absolute in India. Please remember that we have right to religion, we have right to freedom. However, there will be some reasonable restrictions based on public order, morality, or health. Now, our Indian constitution, in Indian constitution, the term secular was added in the preamble part in the 42nd amendment in 1976, emphasizing that India is committed to a religious neutrality and equality. Okay. Now there are some articles which also related to the secularism. First one is Article 14, which ensures equality before law and equal protection of laws to all the people, irrespective of their religion. In front of law or in front of judiciary, all are same. Article 15, similarly, it prohibits discrimination on the ground of religion, race, caste, sex, or place of birth. Article 16 again, it guarantees equality of opportunity in public employment without any discrimination or without any religious grounds. Means everyone will get equal opportunity in public employments or any other thing. Okay. Article 25 itself, it guarantees freedom of conscious, right to profess, practice, and propagate any religion. Means I'll have the right to choose my uh, conscious, or what I will profess, or what I will preach, or what I will practice, or what I will propagate. Again, there are some restrictions. It should not go against any public policy, morality, and etc. All right. Article 25. Article 26 again, it provides right to manage any religious affairs. Okay. And Article 27, it prohibits the state from compelling any person to pay taxes for promotion or maintaining any particular religion. State cannot take money, state cannot do anything, or state cannot compel any person to pay taxes for the promotion of any religion or any kind of religious affairs. All right. Our state does not do that. Article 28 again, it prohibits religious instructions in the education institution wholly funded by the state. Any institution which is wholly funded by the state itself, that institution cannot deliver any religious instructions. Okay, so these are the basic or the key features of the Indian secularism, which is incorporated under Indian Constitution. So there is a case law, SR Bomai versus Union of India, which came on 1994. It is a landmark judgment on secularism. You'll the uh, get the golden words of the Supreme Court, where Supreme Court held that this secularism is actually the basic structure of the Constitution, uh, and it cannot be amended or abrogated by a constitutional amendment. Any state government acting against secular principles can be dismissed under Article 356. Okay, so these are the features, major features of our Indian Constitution. However, well, there are some challenges as well in maintaining all these features. So, in brief, I would like to discuss the challenges. The first challenge is, as I have stated, federalism, center and state relations. Well, increasing centralization of power somehow has sparked some debate over the erosion of cooperative federalism. There should be cooperation between the center and the union, but there are some instances where we have seen clashes among the state and the union. Then fiscal federalism is strained, with state demanding greater financial autonomy amidst the rising of central controlling through GST. Means if a center suppose amends any law, any fiscal policy changes in fiscal policy, there might be a clash between the state laws. All right. Now, judiciary and executive tensions are there as well. Judicial independence is perceived to be under threat due to delays in judicial appointments and acquisition of executive interference. Well, there are instances. So, again, freedom of speech and expression, a controversy related to that is also there. Now, the rise of digital platforms has posed new questions about the regulation of free speech. Now, social media and misinformation actually complicate these balances between free speech and public order as well. This is one of the challenge for Indian constitution. So, and to which what extent we should curtail freedom of speech? Right now, we are seeing there are lots of instances where social media or social media platforms are being used to propagate misinformation or any radical things. All right. Now, evolving human rights, again, one of the challenges. Issues like privacy in this digital era have led landmark judgments, we all know. That Puttuswamy case, it is an important case in this regards, which recognized privacy as a fundamental right. Now, challenges actually persist while implementing gender equality, addressing caste-based discrimination, vote bank policies, minority politics, which somehow it curtails the right or rights of the marginalized communities as well. All right. Now, democratic integrity, electoral process, actually it faces a scrutiny over the influence of money power, fake news, and voter manipulation. Well, there are some instances where we have seen fake news is related to voter manipulations, how money is being played in this electoral process. It is one of the challenges for the democratic, for a democratic country like India. All right. And the last challenge, according to me, that is environmental sustainability and development. Now, balancing economic development with environmental conservation has become a very increasing contentious. All right. There are some principles like sustainable development principles, polluters pay principles, precautionary principles, public trust doctrine, etc. are there. However, apart from that, Article 48A is there, Article 21, lots of cases are there related to environment. However, if we see the stats like air index, water index, and etc., the quality is very much poor. Our constitution and the judiciary is very eco-friendly actually. It is pro flora and fauna. Yet the wildlife crimes like poaching, hunting, and etc. is increasing day by day. Apart from the forestry crimes, I mean, green crimes, it is also a very threat or a very big challenge for this Indian constitution. Okay, so these informations will be from my side. So there are two other panelists as well. They will also discuss about the things. So I'll just conclude from here. Okay, thank you everyone. So if
Thank
there
you
any
so much,
question,
sir.
okay. So if there any question, anyone can ask me. The any questions? Yes, sure. Srinjoy.
Sir, I had a question that as we know that DPSP is for the welfare of the people, but why we cannot pass a single act so that people can use all the provisions of the DPSP?
Actually, DPSP, as I have stated, it is obligatory for the state to follow the DPSP. And you cannot
Yes,
enforce DPSP. State should take guidance from the DPSP only. That is one of the limitation, I think, I guess, for the DPSP. Understood my point? Like
yes,
they can just read the DPSP and they can make laws. Like there is one DPSP, that is equal pay for equal work.
mhm,
Now, when you will work in the corporate sectors, you will understand no one follows that part. You know how the work culture is there outside, right? I think we
yes,
all
sir.
know. So again, this is a challenge for the Indian Constitution and the people of India as well. And this is a reality. It's a reality check for us, youth like us. Okay.
Yes, sir.
Okay. Any other questions? Yes, Priyanka, please.
Sir, you mentioned about delaying the appointment of judges. So, how can we tackle this problem?
Well, it's a very big question because right now, recently, there is a question on the collegium system itself. Okay. The process of appointment of judges, the authenticity of the appointment or the whole procedure is in a big question. There are people who are saying that nepotism is working on this particular part. Previously, if you see the judges transfer case 1, 2, 3, there were lots of cases are there. In the previous process also, uh, that process also failed due to this authenticity. Now again, my in my opinion, uh, power or the politics plays a significant role in this appointments. Somehow they influence a little bit, but yes, there will be an influence. So various factors also play in these appointments. I don't know why, but uh, I think you all have heard that in this collegium system, nepotism also plays a significant role. Means you have to become from money, you have to belong from a judge's family to become a judge or to get into this position. So if actually we need a mass reform in our judicial system for a neutral and very crystal clear judiciary. Otherwise, people will lose faith on this aspect. All right. Unless we do that, there will be delay, there will be confusion among the people. And I know about, I believe the change will come soon. Okay.
Thank you, sir.
Okay. Any other questions? Anyone else? Can Shaksham, can you suggest any kind of reform? So, as a law student, I myself, as a law student, right now, I believe that in collegium system, actually, what to say? Reform is there. Reform is needed actually. However, it is beyond my ability to criticize any judge of our country right now. However, I believe that a judge should maintain a proper profile. There he should not, the person should not be related to any political party there or any members, or an audit should be there on his every judgment. Profile should be there, like which happens in America or USA or any other European countries. Their judges are quite different. Okay. And here in India, we treat our judges like gods. Yes, they are in the supreme position, but they are not gods. They're human beings. They're just maintaining the position. All right. How yet? The yet we are for preaching right to equality.
सर क्या हिंदी में बात हो सकती है?
Hindi, I guess Shubham can manage that. My Hindi is very much poor. I have a very problem in theta too, actually. So I guess the other panelists might help you in Hindi. I truly apologize for that.
कि सर हमारी इंग्लिश थोड़ी बहुत बहुत वीक है तो इसलिए हिंदी में बात होती तो ज़्यादा बढ़िया रहता।
मेरा हिंदी अगर तुम सुनोगे तो anyway, Shubham, can you help me out in that? I
Sure,
think
sir.
yes, yes, yes.
We move forward.
Okay, okay. I think there are no other questions. So
Okay, if anyone have questions, then you can ask in our chat box section, please. Now let's move forward. And now I would like to introduce our second keynote speaker, Mr. Shubham Chatterjee, sir. He is an assistant professor of law at Brainware University in Kolkata. He pursuing PhD in law and cleared West Bengal ACT exam on the first attempt. He is author of 3 books, editor of 2 law books, and co-author of 2 books. He presented 16 research papers in national and international law. Up to you, sir.
Well, thank you so much for this warm invitation from the Lawlicious Committee. I feel truly humbled and privileged to be a part of the panel where I am sharing the seat of panel along with my professor, Mr. Souradipta Bandyopadhyay. I have been his student, and now to share a panel with him is itself a privilege for me. Thank you to the Lawlicious Committee for making this possible. Also, as sir have told that today is a special day for us. So आज का दिन इसीलिए महत्वपूर्ण है क्योंकि at the end of the day, this is the day where our constitution was adopted. इसी दिन हमारे संविधान को अपनाया गया और 26 जनवरी 1950 को इसको लागू किया गया, इन्फोर्स किया गया. उसीलिए 26 जनवरी को हम प्रजातंत्र दिवस के तहत उसको सेलिब्रेट करते हैं और आज का दिन है संविधान दिवस. सो हमें पता है कि भीमराव अंबेडकर ने बहुत ही महत्वपूर्ण भूमिका निभाया इन सो फार एज टू ड्रॉ द कॉन्स्टिट्यूशन, टू राइट द कॉन्स्टिट्यूशन. एंड आज का जो वेबिनार का टॉपिक है संविधान के फीचर्स, इसके अचीवमेंट और चैलेंजेस. And I am at loss of words to start with because my professor, now we share the same side on the other side of the table. Both have like he has spoken his heart out. He has incorporated everything जो भी बोलना था, जितना भी था, he has said everything which is contemporary, which is relevant. But क्योंकि है ये संविधान तो इसका कुछ कुछ अंत नहीं है, ये अनंत है. द कॉन्स्टिट्यूशन ऑफ इंडिया फॉर मी इज अनलिमिटेबल. इसका कहीं पे जाके यू कैन नॉट ड्रॉ अ लाइन वेर इट कम्स टू एन एंड. अब कहीं पे जाके इसको खत्म नहीं कर पाओगे क्योंकि हम लोगों का संविधान का एक बहुत बड़ा फीचर है कि इट इज बॉरोड कॉन्स्टिट्यूशन. हमने संविधान को खुद से लिखा नहीं, हमने विभिन्न देशों को संविधान को पढ़ा, पढ़ के उसके हिसाब से उसका उनका जो भी अच्छे सारे क्वालिटीज है, सभी चीज को हम लोगों ने अडेप्ट किया. अब बात ऐसे हुआ क्योंकि हमने सारा अच्छा जो था हमारे कॉन्स्टिट्यूशन में भर दिए. नाउ इट बिकेम द लेंथीएस्ट कॉन्स्टिट्यूशन एज सर हैज सेड कि भारत के संविधान प्रोबेबली एक ऐसा ही संविधान है जो विश्व के सबसे लंबा संविधान माना जाता है, जहां पे सब कुछ वेरी डिटेल्ड, वेरी इलेबोरेट मैनर में दिया गया है. We have a constitution where we find that there are, as of date, we have almost 448 articles. There are schedules and parts of the constitution. अब भारतीय संविधान का जो पहला फीचर जो नजर आता है वो है प्रियम्बल, प्रस्तावना। ये जो प्रस्तावना है ये शुरू होता है वी द पीपल ऑफ इंडिया बोलकर। कहने का मतलब ये है कि ये जो संविधान ने हम लोगों को मौलिक अधिकार दिया है, फंडामेंटल राइट्स, ये जो डीपीएसपी, डायरेक्टिव प्रिंसिपल्स ऑफ स्टेट पॉलिसी, सरकार को निर्देशना दिया गया है कि वे वेलफेयर एक्टिविटी कैसे करें, या फिर द फंडामेंटल ड्यूटीज हमें जो करना है एज अ सिटीजन ऑफ इंडिया। जैसे सर ने बताया कि स्पाइडरमैन की मूवी में एक अच्छा कोट था, विथ ग्रेट पावर कम्स ग्रेट रिस्पॉन्सिबिलिटी। जब हम लोगों के पास अधिकार है तो हम लोगों का कुछ दायित्व भी है जो हम लोगों को करना पड़ेगा। वी विल हैव टू फुलफिल दिस इज मैंडेट। अब ये जो प्रस्तावना है, भारत का प्रस्तावना, ये कहता है वी द पीपल ऑफ इंडिया, मतलब हम साधारण जो है जनसाधारण, हम ही ने हमारा अपना जो क्षमता है वो क्षमता हमने संविधान को सौंपा है, और उसी संविधान ने मौलिक अधिकार के तहत हमें कुछ अधिकार वापस दिया है। हमारे प्रस्तावना में बहुत क्लियरली ये बताया गया है कि भारत भारत एज ए स्टेट, इसका नेचर क्या होगा। भारत माँ का नेचर होगा सोवरिन, सोशलिस्ट, सेक्युलर, डेमोक्रेटिक रिपब्लिक। हमारे प्रस्तावना में बताया गया है हमारा जो संविधान का ऑब्जेक्टिव है, उद्देश्य है, वो है जस्टिस, लिबर्टी, इक्वालिटी एंड फ्रेटर्निटी। इसका मतलब कि हम कॉन्स्टिट्यूशन में जो भी लिखा है, जितने भी प्रावधान है, हर कुछ, हर कोई, ये जो एम्स और ऑब्जेक्टिव्स, इसी के बीच में ही रहेगा, इससे बाहर नहीं जाएगा। अगर वो बाहर जाता है तो दैट विल बी कंस्टिट्यूट एज समथिंग अनकॉन्स्टिट्यूशनल। और जो असंवैधानिक है, द जुडिशियरी हैज द पावर टू स्ट्राइक इट डाउन। एज सौरदीप्ता सर हैज सेड कि भारत के संविधान के एक अन्यतम फीचर है कि वी हैव इंडिपेंडेंट जुडिशियरी। हमारे पास एक ऐसा न्याय व्यवस्था है जहां पे वो एग्जीक्यूटिव से फ्री है। इसका मतलब कि अगर एग्जीक्यूटिव लेजिस्लेचर कुछ लॉ बनाता है या फिर एग्जीक्यूटिव का कुछ डिसीजन होता है जो संविधान को वायलेट करता है, विच इज अगेंस्ट द कॉन्स्टिट्यूशन, द जुडिशियरी हैज द पावर टू स्ट्राइक इट डाउन ऑन द ग्राउंड्स ऑफ अनकॉन्स्टिट्यूशनलिटी। अब ये जो प्रियम्बल है, इट इज नथिंग, a preamble is a key to open the mind of the framers of the constitution। जैसे दरवाजा का ताला खोलने के लिए हम लोगों का चाबी का जरूरत होता है, वैसे ही प्रस्तावना, भारतीय संविधान की प्रस्तावना पूरा कॉन्स्टिट्यूशन का एक रूपरेखा देता है। द प्रियम्बल एक्ट्स एज अ गाइडिंग लाइट फॉर द कॉन्स्टिट्यूशनल इंटरप्रिटेशन। At the same point of time, the preamble promotes a sense of national integration and unity। प्रस्तावना के जो उद्देश्य है, जस्टिस, लिबर्टी, इक्वालिटी, फ्रैटर्निटी, यूनिटी एंड इंटीग्रिटी, दिस ऑल स्पीक्स अबाउट नेशनल यूनिटी। कहीं ना कहीं ये प्रिंसिपल्स को भारत की प्रस्तावना दर्शाता है। एक समय आया था जहां पे क्वेश्चन अराइज हुआ था कि प्रस्तावना संविधान के पार्ट है कि नहीं है। बेरोबरी यूनियन केस में बताया गया था कि प्रस्तावना अर्थात प्रियम्बल इज नॉट ए पार्ट ऑफ द कॉन्स्टिट्यूशन, बट दैट हैज बीन ओवररूल्ड इन केशवानंद's केस। The Keshavananda Bharati judgment has clearly pointed out that the preamble is part of the constitution। It has not only made the केशवानंद केस सिर्फ प्रियम्बल को पार्ट ऑफ द कॉन्स्टिट्यूशन बोलकर ही सीमित नहीं रखा, उससे आगे चलकर प्रस्तावना को बेसिक फीचर ऑफ द कॉन्स्टिट्यूशन में इनकॉर्पोरेट कर दिया गया। और ये बेसिक फीचर जो है ये भारतीय संविधान के और एक सेलिएंट फीचर है। अब आपको कहीं पे भी बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन भारतीय संविधान में लिखा हुआ नहीं मिलेगा। इट इज अनरिटन। It is a doctrine evolved by the judiciary, maintained by the judiciary, carried forward by the judiciary with the passage of time. बेसिक स्ट्रक्चर है क्या? कॉन्स्टिट्यूशन के जो फंडामेंटल प्रिंसिपल्स है, लेजिस्लेचर के पास पावर है लॉ बनाने के लिए, कॉन्स्टिट्यूशन को अमेंड करने के लिए, लेकिन to the extent that it does not violate the constitutional principles, constitutional morality. Where there is a clash, where there is violation of constitutional principle, at the end of the day, that will be struck down because that violates basic structure of the constitution. And basic structure is something that is closely twinned, closely knitted with our constitutional structure, with the constitutional fabric of the nation. आप इसको चेंज नहीं कर सकते हो। और प्रियम्बल बेसिक स्ट्रक्चर ऑफ द कॉन्स्टिट्यूशन के पार्ट है। हमारे अगले फीचर है बाइकैमेरल लेजिस्लेचर। इंडिया में जो लॉ मेकिंग बॉडी है उसको पार्लियामेंट कहा जाता है यूनियन लेवल पे, और स्टेट लेवल पे इट इज नोन एज लेजिस्लेटिव असेंबली। I mean the legislative body. Now the thing is that there are two houses. One is the upper house, one is the lower house. सेंट्रल स्ट्रक्चर में अपर हाउस को राज्यसभा बोला जाता है, विच इज ऑल्सो नोन एज द काउंसिल ऑफ स्टेट, एंड लोअर हाउस को लोकसभा बोला जाता है। एट द सेम पॉइंट ऑफ टाइम स्टेट लेवल पे अपर हाउस को बोला जाता है लेजिस्लेटिव काउंसिल, विधान परिषद, एंड द लोअर हाउस इज नोन एज लेजिस्लेटिव असेंबली, विधानसभा। अब when we have bicameral structure, इसमें बेनिफिट होता है ये कि जो लॉज बनते हैं, जो कानून आते हैं, वो कानून पीयर रिव्यूड होते हैं, क्रॉस चेक होते हैं। अगर हमारे पास एक ही हाउस रहता, बिल आता, डिस्कशन होता, जो मेजॉरिटी है उनके हिसाब से वो लॉ पास हो जाता, that would have become a law. Because to get the sign of the president is no big deal. वो कुछ भी नहीं है। सरकार जिसका, राष्ट्रपति उसका। राष्ट्रपति से साइन कराना चुटकी का बात है। और हमारे कॉन्स्टिट्यूशनल फ्रेमवर्क में द प्रेसिडेंट इज नथिंग बट ए बर्ड इन ए गोल्डन केज। सोने के पिंजरे में पक्षी का रहन सहन कुछ भारतीय संविधान के राष्ट्रपति, भारत की राष्ट्रपति के पद और गरिमा से मिलता है, क्योंकि इंडिया's president holds no real power. He is the nominal executive. The real executive is the prime minister along with the council of ministers. जब पद है लेकिन क्षमता है नहीं, what can you do? You have designation, you have no power. What are you supposed to do with your designation? To bring change, you require power. अब जब बाइकैमेरल लेजिस्लेचर का बात आता है, बेनिफिट ये है कि एक कानून लागू होने के लिए आपको दोनों हाउस से पास करवाना पड़ेगा, एक्सेप्ट फॉर फाइनेंशियल बिल्स, जहां पे लोकसभा का पावर ज्यादा है एज कंपेयर टू राज्यसभा. And at the same point of time, in a rush, आप कुछ कानून लाना चाहते हो. अगर सिंगल हाउस रहता, at any point of time, the legislature can sit and bring a law. When we have opposition, when we ensure that the opposition also gets the opportunity to speak, to be heard, the principle of audi alteram partem, no one should be left unheard, is followed. Legislatures cannot make arbitrary law in hurry and rush. Never it can make. Not possible. Again, if I look at the constitutional structure, another feature that comes to my mind is single citizenship. In India, we have a federal structure of government, but we do not have full federal structure. We have quasi-federal structure of government. Now, this quasi-federal structure implies combination of your unitary features and federal features. And single citizenship in India is a blend of a tilt towards the unitary feature of the constitution. आप अमेरिका में चले जाओ, they have dual citizenship, one of the country and one of the province that they reside. अब कनाडा में चले जाओ, वहां पे one of the province, one of the country. So they have dual citizenship. But in India, we have only one citizenship. आप यूपी से हो, आप बिहार से हो, आप तमिलनाडु से हो, आप वेस्ट बंगाल से हो, आप असम से हो, आप गोवा से हो, you be from any part of India, it doesn't matter. You have only one identity, and that identity is you are an Indian. Nobody is going to ask you which province you are from. That is what makes India to be, again, you know, a zara hatke wala feature insofar as federalism combined with unitary features are concerned. Next feature that we have is the feature of emergency. We are all law students. We are all aware of what emergency is. Uh, so basically, emergency is a situation, a tense situation where you are not able to control, where you are not able to operate the governance as per the constitutional mandate. Because आप अगर कॉन्स्टिट्यूशन को अच्छे से पढ़ोगे तो आप देख पाओगे आर्टिकल 1 clause 1 says India, that is Bharat, shall be union of states, which means the sum of 28 states plus 9 union territories that we have right now together makes India. Therefore, all the provinces, all the states, all the union territories, they are mandated to be run as per the constitutional structure. If that is not been followed, a situation of tension arises, and at that point of time, the only thing that can happen is to impose precedence rule. We have in our constitution three different kinds of emergencies: the national emergency, the state emergency, the financial emergency. नेशनल इमरजेंसी 1975 में इंदिरा गांधी गवर्नमेंट ने जिस तरह से अपने क्षमता का अब्यूज ऑफ पावर किया और उसके चलते जैसे उन्होंने इमरजेंसी को लागू किया, where the entire fundamental rights was taken away, the freedom of press was taken away, and the country was put into blindness. In that particular scenario, the only thing that happened is post waiving of the emergency, there was huge changes that were brought into the provision of the constitution insofar as emergency is concerned. भारत में अब तक फिनेंशियल इमरजेंसी एक बार भी लागू नहीं हुआ। 1991 में एक सिचुएशन आया था जहां पे फिनेंशियल इमरजेंसी वाज अबाउट टू बी डिक्लेयर्ड, बट द देन फिनेंस मिनिस्टर ऑफ इंडिया डॉक्टर मनमोहन सिंह 1991 में नरसिम्हा राव की सरकार था तब, so 1991 में under Narasimha Raw's leadership and Manmohan Singh's vision, the financial emergency was curbed. It was not put into effect. Till date, we have no financial emergency. And when we look at another feature, that is the reservation policy. So technically, we have been, we have been speaking about Bharat at 75, India at 2047, India at this, India at that. Technically, today, if I go back and reflect India at 75 years, India's constitution on the outset of 75 years, I would say the reservation policy as a feature of the constitution was progressive to the extent when it was required. आज के दिन में if we are taking advantage of the reservation policy, I'm sorry to say that can be anything that you can call, but we are not developed. अगर आज भी सिटीजन्स को रिजर्वेशन पॉलिसी अपनाना पड़ता है टू गेट अ जॉब, टू गेट एडमिशन इनटू डिग्री कॉलेजेस, टू आईआईटीज, टू एम्स एंड टू आईआईएम्स, India is not developed. This is a sorry state of affair. Because जब कॉन्स्टिट्यूशन बना था तब SC, ST, OBC, socially and educationally backward class, their condition was very poor. It demanded reservation so that ताकि जो पीछे रह चुका है उन लोगों को मेन स्ट्रीम ऑफ द सोसाइटी में लाया जा सकता है। आज जब हम बात कर रहे हैं 75 years ऑफ इंडियाज कॉन्स्टिट्यूशन, अगर हम आज भी रिजर्वेशन पॉलिसी को सपोर्ट करते हैं, उसको आगे ले जाते हैं, इसी को बेसिस बना के हम सोचते हैं कि हाँ ठीक है, मेरे को तो अच्छा एनएलयू में एडमिशन मिल ही जाएगा क्योंकि मैं SC ST से हूं, मेरे को तो वो एग्जाम मैं क्रैक ही कर लूंगा क्योंकि मेरे कट ऑफ मार्क्स तो कम रहेंगे, देन द मेरिट इज कॉम्प्रोमाइज्ड। कुछ ही दिन पहले आई वाज सेइंग फॉर अ पर्टिकुलर स्टेट आई सॉ a meme which was circulating. A general category student नीट एग्जाम में उसको 47 मिला, he did not qualify for the seat, मिलना भी नहीं चाहिए। 47 मार्क्स मिलकर अगर कोई जाता है MBBS पढ़ने के लिए तो वो डॉक्टर मरीज को कितना ठीक करेगा और वो कितना खुद ठीक रहेगा इज द क्वेश्चन। बट सेम एम्स का बात मैं बता रहा हूं, बट देयर वाज अ गाय फ्रॉम रिजर्वेशन कैटेगरी जिसको नेगेटिव में मार्क्स मिला। दैट गाय वेंट ऑन टू सिक्योर अ सीट And I'm speaking of a very reputed aims. Now think of the quality that we are compromising with. When we get, even as far as appointment into the educational sector, if I say, we see, we know that to be appointed as professor, you would be required to either qualify for net or for respective set examination, competitive exam से आपको, that's only qualifying criteria. Trust me, when you get a professor from general category, please consider yourself to be someone who is very lucky. I agree that there would be persons who, despite clearing, might not be able to convey the things properly. But if you are getting someone with, if you're getting someone with, uh, who is from the reservation category, their cutoff marks is very low. Think of a general category people requiring 220 plus marks to qualify to be professor, and a reservation category requires 130, 140. Look at the quality, look at the merit that you have been compromised with. This poses a serious question: ki what we have achieved, what our constitution has achieved today. It's a very pondering state of affair. Now, if I go to the challenges that we face, I spoke about preamble. Preamble में जो terms are secular socialist, as Sarah has also told, कि this terms are used for political gain. आपको पता कैसे चलेगा? Secular क्या है? कैसे अडॉप्ट करना चाहिए? कैसे होना चाहिए? You cannot know that. Different political parties are using it as per their convenience, as per their wish. That is a challenge for our constitution. When I have spoken about bicameral legislature, दो सदन रहने से बहुत अच्छा है कि एक कानून जो आता है वो बहुत अच्छे से पास होके आता है. इसका एक डिमेरिट भी है, इट इज वेरी टाइम कंज्यूमिंग. यू अगेन, जो अपर हाउस है राज्यसभा का इंपॉर्टेंस बहुत 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 ही घट जाता है. It's a challenge. If both the houses enjoy the power of making the law, both the houses should enjoy the equal power. That is not present. When we speak about single citizenship, भारत में सिंगल सिटीजनशिप का तो प्रोविजन है, लेकिन जो माइग्रेटरी वर्कर्स है, जो अपने राज्य को छोड़कर दूसरे राज्य में जाते हैं काम करने के लिए, अपना धंधा करने के लिए, क्या उनको वैसे ही मर्यादा दिया जाता है जैसे कि एक लोकलाइट डोमिसाइल को दिया जाता है? Go back to the society and see and check. No, it is not given. Matlab, if you belong from the intellectual class, you are moving from one state to another, you have talent, the people will, at least tell you, at least will, give you some weightage. If you fall in the gig economy sector, no, despite single citizenship, you have nothing. Emergency provision. इमरजेंसी जब लागू होता है, स्टेट गवर्नमेंट का पावर चला जाता है. स्टेट गवर्नमेंट होता है तो इलेक्टेड गवर्नमेंट, बट व्हेन इमरजेंसी इज इन फोर्स, द स्टेट गवर्नमेंट हैज नो पावर एट ऑल. तो है ही क्यों इलेक्टेड गवर्नमेंट? आपको वहां पे भी जाकर क्वेश्चन रेज करना पड़ेगा. एज अ स्टूडेंट ऑफ लॉ, वी शुड ऑल अंडरस्टैंड दैट we are primarily the students of constitutional law, because the constitutional law is the mother of all the laws. We cannot avoid anything pertaining to constitution. When we reflect on India's achievement, India at 75, we should always ensure that somewhere or the other we are going to make India an independent country, a self-reliant country, at the same point of time balancing whatever the constitution has granted to us. You cannot take away the ethos, moralities, principles for the sake of development, for the sake of prosperity. Again, altogether, that makes up to be some another topic that we can always, discuss on any other thing. So, with this, I would like to conclude my opinion. If there are questions, I would be more than happy to take. Yes, Vidushi.
Good evening, sir. Sir,
Good evening.
there is now a new concept of savior sibling in India. It is a sibling which is born through a IVF to save his or her elder sibling. So, sir,
Mhm.
is it constitutionally valid or ethically valid, more or less like?
See, you have spoken two terms. One is constitutionally valid, one is ethically valid. So these two terms are quite contradictory. Whatever you do ethically might not be legally valid, and the other way around is also possible, right? Over there. So this is it is too early to comment on it, because we have to at least wait for, हमें कुछ रुझान की जरूरत है, at least from any high court or from the supreme court, to understand the scenario, understand the happening. Like, but to me, if you ask me my opinion on this particular day, today itself, if you ask me at this point of time, I would say to some extent it is ethically valid.
Okay, sir. But sir, I have an opinion that any child who has just came into the world just to for providing spare parts, which includes blood, cells, or bone marrow, or something, some, or even any organ. So,
Mhm.
sir, at one point when he or she gets to know about this, he or
Hmm.
she will feel when a big trauma, like
Hmm.
they will become underconfident, or they will feel like I am I this much worthless that my parents just only brought me into this world to care for my elder siblings. So, sir, I don't think so. It is ethically valid. And sir, this case has happened in 2019 where a first savior sibling baby, Kavya Solanki, was born just to save
Okay.
her 7-year-old brother, which I agree that, but doesn't it in is I think so it violates the her constitutional right as well. Section 19, sorry, Article 19A of constitutionally gives us the right to express
Hmm.
our freedom of speech,
Hmm.
has given us the right to freedom of speech and expression. But sir, she was just a newborn and no consent of her was taken that whether she wants to save her brother or not, whether she wants to give her bone marrow or not. So, sir,
Hmm.
is it constitutionally valid? Because it is denying Article 14, Article 19, and Article 21 as well.
Hmm.
So, it is defining, like violating the golden triangle of the constitutional.
Yes, it does violate the golden triangle of the constitution. I totally agree. But at the same point of time, you should also understand about the right to live with dignity. Somewhere that is also happening as a contradictory, right? Over there.
But sir, if we see the what about the mental health of the child when he or she gets to know about this?
That is altogether a separate issue again.
Okay. Okay, sir. Thank you, sir.
Thank you.
Thank you so much, Shubham sir and Swaradipta sir, for your wonderful sessions. We have learned a lot from your sessions, and I am extremely sorry that our third keynote speaker has not come. She had a sudden emergency, so we apologize to you guys on her behalf. Uh, and one notice for you all: the certificate will be given to those who will fill the feedback form, which is given in the chat box session, and those who will not fill the feedback form, the certificate will not be provided to them. And the certificate will be given within 2 or 3 days. So guys, go and fill the feedback form, which is given chat box session. And thank you so much, sir.
Ma'am, it is not getting open. I tried it many times, but it is not accepting responses.
मैंने वापस भेजा है, एक बार करके देख लो.
Still same, not accepting responses.
Okay, wait for a while.